quote-unquote, host today's very historic public lecture that we're going to hold today. And the topic, of course, you all are aware, today's public lecture is on the July Uprising, or rather the July mass uprising in legal thoughts. For today, we are going to technically revisit the pivotal moment in the history of our nation that took place last year on the 36th of July 2024. Of course, today's lecture would primarily focus on exploring the movement's influence in legal thought, the resistance, jurisprudence, and the constitutional evolution of the country. And we are going to revisit these through, of course, our distinguished guests and distinguished guests for today. Before moving on to our next step, I would like to introduce, or rather ask our guests to kindly come and take their seats in the stage. I would like to request Professor Mohammad Nazmuzzaman Bhuiya to come and welcome our guests to the stage. Now I'd like to honor our guests of honor and the chief guest of today's event, that is the keynote speaker, Mohammad Shahabuddin, Professor of University of Birmingham, United Kingdom, and the chief guest, that is the Professor SM Faiz, PhD Chairman, UGC Bangladesh, and honor them with a welcoming bouquet. Nazmuzzaman Bhuiya to come and give his welcoming speech in today's event. Thank you.
Chair of today's public lecture, Professor M. Tamim, Vice Chancellor, IUB. Our chief guest, Professor SM Faiz, Chairman, University Grants Commission of Bangladesh. Today's guest of honor, Mr. Didar Hussain, Chairman, Board of Trustees, IUB. Professor Dr. Burhanuddin Khan, Advisor, School of Law. and our beloved Professor Muhammad Shahabuddin from University of Birmingham, today's keynote speaker, distinguished guests, my colleagues from IUB, and my dear students. Very good morning to you all and welcome to this public lecture. So far I remember that during the last 1 year, since 5th August 2024 to yesterday, the 5th August 2025, we have organized several events, even in this auditorium, regarding the July Uprising. And I personally spoke also on 1 or 2 occasions. But today, after 1 year, we are actually going to re-evaluate that what we achieved on 5th August 2024 and after 1 year, where we do stand today. Yesterday, I was at Dhaka University. Different programs are organized, and even the day before, regarding this particular event, which we call July Uprising. So there are a lot of memories, a lot of emotions, and definitely a lot of expectations. But the School of Law, IUB today, is going to discuss this particular terminology from legal perspective. Whether it was a revolution or an uprising, there was a lot of debate since the beginning. Those who are law students present here, you know that we do have a course, Legal Terminology and Phrases. Not necessarily oral legal terms, but there are different terms which do have legal explanations, legal interpretations. So what exactly the basic differences between these two? And even if it's revolution, is it active or passive? So that is certain things we need to discuss if we actually look forward to the future of Bangladesh, when we all believe that we are going to establish rule of law in a new Bangladesh, free from fascism, free from autocracy, and free from all sorts of torture and ill treatment. We do have a lot of memories that we can never forget. 5ই অগস্ট যেটা গিয়েছে গতদিন, আমরা সবাই সেগুলো মনে করছিলাম। 5ই অগস্ট যেটা একটু আগে বললাম, যেটা দ্বিতীয় স্বাধীনতা কিনা জানি না, বাট বিষয়টা খুব সূক্ষ্মভাবে দেখলে 5ই অগস্ট সকালবেলা when we found that all sorts of preparations were going on throughout the night, কে কিভাবে সকালবেলা বেরোবে, কি নিয়ে বের হবে, কিভাবে বের হবে, কোথায় যাবে, কিভাবে পুলিশের চোখ ফাঁকি দিবে, কিভাবে তারা গণভবন পৌঁছাবে, তার যে প্রিপারেশনস যুদ্ধের চাইতে কম ছিল না। সকালবেলা আমার ওয়াইফ যখন বেরোবে, তখন বলছে যে আমরা দুজন বেরোবো কি না, then we decided যে না, কেউ একজন আমার মেয়ের সাথে থাকতে হবে। So she decided she would go, because ওখানেও একটা পার্সপেক্টিভ ছিল যে মেয়েদের সামনে থাকতে হবে। সো বের হওয়ার সময় যখন তার অর্নামেন্টসগুলো আমার হাতে দিয়ে বলল, যদি না ফিরি তা আমার মেয়েকে এগুলো দিও। সো সেই 5ই অগস্ট তার ঠিক 12টা বা 2টার সময় আমাদের যে ফিলিংসটা, বিশেষ করে এখানে আমরা দুজন আছি, শাহাবুদ্দিন আর আমি, 71 পরবর্তী প্রজন্ম, যারা 16ই ডিসেম্বরের বিজয় দিবসের অনুভূতি আমরা পাইনি, তাদের কাছে আমার ধারণা 5ই অগস্ট তার চাইতে কম কোনো অনুভূতি ছিল না। সো সেই পার্সপেক্টিভ থেকে দেখলে আমরা বুঝতে পেরেছিলাম অন্তত 5ই অগস্টে যে বিজয়ের আনন্দ কেমন হতে পারে। সো একদিকে ছিল শোকগাথা, আরেকদিকে বিজয়। এই দুটার যে মিশ্রিত অনুভূতি 5ই অগস্টে, সেটাকে সামনে রেখে ঠিক গতকালকে আমরা যে নিজেদের স্মৃতিচারণ করেছিলাম, সেটাকে মাথায় নিয়েই আজকে আমরা একটু দেখব যে if it is even July uprising, then from legal perspective, where do we stand today and where we should head towards. Professor Shahabuddin, we were together in London. We both were doing our PhDs. I returned, he stayed back. Which one was a good decision, I still don't know. But it's amazing to find that he is here today at IUB to give this public lecture before my law students and the other students from IUB. So I should welcome Shahabuddin to IUB and to this public lecture, and also our honorable guests and the audience to this thought-provoking lecture on July Uprising in Legal Thoughts. Thank you very much.
Thank you very much, Professor Nazmuzzaman Bhuiya, for an excellent introduction. Just a correction, I did actually return, yes. And I did set up as the founding chair of the Department of Law and Justice at Jahangirnagar University. Then, of course, as you said, I left. Now, I think it makes the situation even worse. We can talk about that later. Honorable Chief Guest of today's occasion, Honorable Guest of Honor, and Honorable Chair of this today's event, thank you so much for sparing your time and to come and join us for this important event. I'm sure you have far more important things to do in life, but you decided to come and join us this morning, for which I'm immensely grateful and humbled. Thank you so much. And thank you also to the audience for joining us to listen to me. I'm not sure whether I can do justice to your time and the commitment that you have made. And of course to Professor Burhanuddin Khan, who happened to be my direct teacher at the University of Dhaka Law School many years back. If I remember correctly, Sir used to teach us Civil Procedure Code in our final year, and then of course we worked in various capacities together for a very long period of time. Now, after this thank you note, I must start by paying my tribute to the martyrs of July Uprising or Revolution, whatever you prefer to call it. And I know that thousands of our young fellows are currently suffering from various life-changing injuries and struggling in hospital beds, and my heart goes to them and their family members, and especially those who have left behind their near and dear ones. When we talk about academic events and academic thoughts, something quite theoretical as I'm going to talk about today, we have to really understand the broader context, the emotional context that Professor Nazmuzzaman Bhuiya was talking about. So I would encourage you to actually have some sort of sympathy towards what I'm going to tell you, because when you see the bigger picture of human suffering and human cost that actually brought forth this massive change in our political, social, and personal lives, probably this kind of academic discourses do not make much sense. But then these discourses matter, because that is what academia do, that is what we do as trained professionals, to engage with ideas, to debate over ideas, to disagree over ideas. And I think that is how we move forward. Before I start, I'll have to also make a disclaimer. Whatever I'm going to say you in the next 1 hour or so, absolutely personal capacity, which means my home institution, the University of Birmingham Law School, and my host institution today, Independent University Bangladesh, they do not necessarily endorse, support, or whatever what I'm going to tell. So I'm absolutely speaking in personal capacity, and if I make any blunder, if I say something by late afternoon. Killing the governor and parading the head on a pike. That evening, King Louis XVI reportedly asked the Duke of Rochefoucauld, I quote, "Is this a revolt?" To which the Duke replied, "No, sir, this is a revolution." Fast forward 2024. On August the 5th, 2024, the then Prime Minister Sheikh Hasina fled to India in the face of nationwide uprising led primarily by students. This brought a dramatic end to Hasina's authoritarian regime. The UN Human Rights Office fact-finding report on Bangladesh confirms that to suppress the uprising, law enforcement agencies, together with the country's security and intelligence apparatus, as well as violent elements associated with the ruling party of the time, they systematically killed at least 1,400 individuals, including 133 children. The uprising soon came to be known and celebrated as the July Revolution or the Monsoon Revolution. Senior political leaders of major political parties in opposition, as well as civil society representatives, were quick to call it a revolution in their speeches and interviews. Also, in a speech on 7 December 2024, the Honorable Chief Justice of Bangladesh recalled, I quote, the resolute spirit of student-led revolution of July and August 2024, which catalyzed the movement to oust oppression and restore justice, equality, and humanity. End of quote. In January 2025, a senior advocate of the Supreme Court of Bangladesh filed a writ petition challenging the legality of the current interim government led by Professor Muhammad Yunus as the chief advisor. The petition argued that a revolution destroyed the entire source of constitutional power and a revolutionary government under an instrument of provisional interim constitutional order should have been installed. Instead, a hodgepodge, according to the petitioner, a hodgepodge exists, making the interim government controversial and without any legal authority, as it is not backed by any legal instrument, again, according to the petitioner, and can be termed as a usurper government. The High Court bench found this writ petition, I quote, misconceived, malicious, and vexatious. In its judgment, the court noted that, I quote, the President of Bangladesh is in a unique situation in the history of Bangladesh. Upon taking advisory opinion, as per Article 106 of the Constitution, he has acted as per the opinion of the Supreme Court. It is therefore backed, the government is backed by the legal instrument as well as backed by the will of the people of Bangladesh. I'll return to this specific legal point later. For now, the interesting part is what the court said next. I quote, the mass uprising this time that took place in July-August 2024 is a part of our history, and hopefully this will remain in good care of the people for many years to come. End of quote. Points to be made here are these. For the court now, in January 2024, it is a mass uprising as opposed to a revolution, and it is already a matter of history, a matter of the past, as opposed to a history in making. And finally, on the 1st of July 2025, a well-known political analyst and an academic wrote an opinion piece in one of the leading Bengali dailies to evaluate the success and failures of the July uprising on its first anniversary. This is what the person in question wrote on the question of July Revolution. I quote, একটা বড় প্রাপ্তি দিয়ে শুরু করা যাক। এটা হচ্ছে 5 অগাস্ট শেখ হাসিনার পতনকে বিপ্লব বলে সংজ্ঞায়িত করার চেষ্টা ব্যর্থ হওয়া। এমনকি যারাই চেষ্টা করেছেন তারাও সরে এসেছেন এই চেষ্টা থেকে। তাদের মধ্যে সবচেয়ে গুরুত্বপূর্ণ মানুষগুলোকেও এখন গণ অভ্যুত্থান শব্দটি ব্যবহার করতে দেখছি। এমনকি স্বয়ং প্রধান উপদেষ্টা শুরুর দিকে জাতির উদ্দেশ্যে প্রদত্ত ভাষণে বিপ্লব শব্দটি ব্যবহার করলেও পরবর্তী সময়ে ব্যবহার করেছেন গণ অভ্যুত্থান শব্দটি। শেখ হাসিনার পতনের পর আমরা যা করেছি সেটা বিপ্লব নাকি গণ অভ্যুত্থান, এটা আমাদের চাওয়া পাওয়ার হিসাব মেলানোর জন্য খুবই জরুরি। এরপর উনি বলছেন, মাঝখানে অনেক ছিল, মাঝখানে শেষের দিকে উনি বলছেন, এই অভ্যুত্থানের সুফল আমরা যতটা পেলাম শেষ পর্যন্ত সেটা খুব সন্তোষজনক নয় বটেই। যদি শুরুতেই এই গণ অভ্যুত্থানটাকে বিপ্লব বলে সংজ্ঞায়িত করার চেষ্টা না করতাম এবং একটা দক্ষ সরকার পেতাম, তাহলে এর সর্বোচ্চ সুফল পাওয়ার সম্ভাবনা ছিল। একটা বিপ্লবের কাছে একটা জাতি বা রাষ্ট্র যা চাইতে পারে, একটি গণ অভ্যুত্থানের কাছে কোনোভাবেই সেটা চাইতে পারে না। বাস্তবতার জমিনে দাঁড়িয়ে যদি আমরা আমাদের গণ অভ্যুত্থানটাকে এবং এর ধরনটাকে সঠিকভাবে আত্মস্থ করতে পারতাম, তাহলে আমরা অনেক বেশি বাস্তব স্বপ্ন দেখতে পারতাম, বাস্তবায়নযোগ্য লক্ষ্য ঠিক করতে পারতাম। সব কিছু পরও আমাদের গণতান্ত্রিক পথ চলার প্রধান বাধা শেখ হাসিনাকে ক্ষমতাচ্যুত করে পালিয়ে যেতে বাধ্য করতে পেরেছি আমরা, এবং এর পরবর্তী সময়ে বিপ্লবের নামে দেশকে নৈরাজ্যের দিকে নিয়ে যাওয়ার যে চেষ্টা, তা ব্যর্থ করতে পেরেছি আমরা। এগুলো আমাদের বড় অর্জন। এন্ড অফ কোট। আমি যেটা দেখানোর চেষ্টা করেছি সোফার আপনাদেরকে, যে জুলাই 5ই আগস্ট 2024-এর পর শুরুতে বিপ্লব, জুলাই বিপ্লব, বর্ষা বিপ্লব, ক্রমান্বয়ে এটা গণ অভ্যুত্থানের দিকে পরিচিতি পাওয়া, এবং সবশেষে এবছর জুলাইতে এটাকে যে শুরুর দিকে বিপ্লব বলা হয়েছে, সেটাই যে একটা সমস্যার কারণ এই পর্যায়ে আসা। এবং পুরো ঘটনাটাই ঘটেছে মাত্র 12 মাস সময়ের মধ্যে। এটা একটা অভূতপূর্ব ব্যাপার, এবং সেই প্রেক্ষাপটে এটা খুবই গুরুত্বপূর্ণ যে আমরা কিছুটা সময় ব্যয় করি জানার জন্য বিপ্লব জিনিসটা আসলে কী। A widely accepted general definition of a revolution presents it as, I quote, the process by which visionary leaders draw on the power of the masses to seek to forcibly bring into existence a new political order. বিপ্লবের অনেকগুলো সংজ্ঞা আপনারা অনেক জায়গাতে পাবেন, বাট মোটামুটি মূল কথাগুলো এখানেই আছে। এবং যদি একটু জুম ইন করি আমরা, তাহলে দেখতে পাবো এখানে 4টি কোর এলিমেন্টের কথা বলা আছে। প্রথমটি হচ্ছে একটা ম্যাস মোবিলাইজেশন হওয়া, যেটা আমাদের জুলাইতে হয়েছে। দ্বিতীয়টি হচ্ছে ফোর্সিবলি দ্য ওভারথ্রোয়িং দ্য গভর্নমেন্ট, যেটাও হয়েছে। থার্ড, দ্য পারসুট অফ এ ভিশন অফ এ সোশ্যাল জাস্টিস। এবং 4 নম্বর যেটা, সেটা হচ্ছে দ্য ক্রিয়েশন অফ এ নিউ পলিটিক্যাল ইনস্টিটিউশন। এখানে শুধু পলিটিক্যাল পার্টির কথা বলা হচ্ছে না, লাইক র্যাডিক্যালি ডিফারেন্ট পলিটিক্যাল ইনস্টিটিউশন। এবং যেটা অথর যিনি আছেন গোল্ডস্মিথ, উনি বলছেন যে যখন এই 4টি উপাদান একসাথে থাকবে, তখনই শুধুমাত্র একটা বিপ্লব হিসেবে সংজ্ঞায়িত হতে পারে। অ্যান্ড অ্যাকর্ডিং টু হিম, দিজ আর দ্য কম্বিনেশন অফ 4 elements that makes a revolution different from uprisings, peasant revolts, riots, military coup, civil wars, social movements, and so on and so forth. But probably this is not a good idea just to stop here with the definition of a revolution. To understand its nitty-gritty and how it operates, it's also important to look into the very nature of what a revolution really is. And then actually it becomes quite complicated. So we have started with this kind of etymological exposition of what we know as a revolution. There are 2 primary ways in which we can understand this kind of evolution of revolution itself. The first one understands a revolution as a cyclical phenomenon. The term revolution derives from the Latin revolutio, meaning to relapse, to revert, to be brought back, to restore, very much like a revolving chair, right? That's the core term. In 12th century Europe, the idea of revolution as a kind of circular movement came primarily to describe the specific action of celestial object rotating. After the peasants' revolts across England in 1381, the word revolution was rapidly referring to an alteration, a change, and an upheaval. And by 1521, the term had become interchangeable with that of rebellion, that is to overthrow the established government or social order by people previously subject to it. The glorious revolution of 1688 registers 2 opposing meanings of the term. On the one hand, it connotated radical political transformation and upheaval marked by the change from an absolute to a constitutional monarchy. But at the same time, on the other hand, this revolution was also deemed glorious because it involved the restoration of the monarchy to its rightful place, a restitution of political and legal order. In that sense, revolution is quite cyclical as a phenomenon. And another comparable example might be the Meiji Restoration of 1868 in Japan, where you went through massive and radical societal transformation, but at the same time, you ensured the continuity of the imperial household from Kyoto moved to Tokyo. So these are examples of kind of revolution in a cyclical sense, which embeds this idea of restoration. The second meaning of revolution, or the second nature of revolution, it's not working. Oh, yes, is revolution as a rupture, which is fundamentally different from this idea of cyclicity. It is the French Revolution of 1789 that fundamentally separated the concept of revolution from its cyclical etymological meaning to connote a singular and distinctive rupture with the past. Revolution would thereafter come to mean the fundamental, total, systematic, and radical social, economic, political, and legal change within a society, nation, or the state. In particular, revolution became synonymous with rupture and radical change as opposed to cyclicity and continuity and restoration. In contrast to the cyclical phenomenon, the French Revolution was perceived to inaugurate a new linear time that moved into inexorably towards progress, freedom, and emancipation, a better but yet unknown and unknowable future. In that sense, revolution embeds a kind of continuity in a different way towards an unknown process, a kind of ever-changing future. Now, against this kind of definition and the phenomena of revolution as cyclicity and rupture, where does the July Revolution stand? In the case of Bangladesh, it is yet to be seen whether the successful mass mobilization in July and the ensuing overthrowing of the government in August would ultimately lead to an inclusive politics with respect for non-discrimination, social justice at its heart, or whether new political institutions, not just political parties, we have seen the mushroom growth of such political parties in recent times, but we are talking about something bigger, whether those would emerge to materialize alternative pro-people political vision. We are not yet there. And the feeling I'm getting after coming to Bangladesh after a couple of years is this, sense of frustration already. As soon as the Hasina regime was toppled, political elites in Bangladesh had to grapple with the new reality. Hasina's fall was sudden, although long cherished. The fact that a sitting prime minister handed in resignation and fled to another country is a first in Bangladesh, despite the country's murky political history. It never happened before. Senior political leaders of major political parties in opposition were quick to call the mass uprising a successful revolution in their speeches and interviews, at least for the first couple of days. It is almost clear now that their choice of the term revolution, intentionally or unintentionally, was more about riding the wave. Within a matter of weeks, they refocused their energy to distancing themselves from what they themselves called a revolution. The scary thought of a revolution and the typical imagery that it brings along in the immediate aftermath, disruption, turmoil, demise of political structures that they have ever known, these were enough for them to disown what they called a revolution, not to mention regional and international pressure and concerns. I'll talk about that later. For them, even if this is a revolution, it must be in the cyclical sense, a process through which the fascist regime has collapsed. The concern is how quickly politics can return to some sort of normalcy. What major political entities were nervous about, and you can always argue that they were right about it, but the nervousness was there, and the nervousness was about the possibility of any rupture or any discontinuity in the political or constitutional structure. Political horse trading that we see these days in the National Consensus Commission meetings is a more recent example of that nervousness, I would say. In such situations, political, bureaucratic, military, and other elites usually seek the refuge under the protective wings of the law. Revolution is not a legal concept per se, But when the legitimacy of a revolution is assessed within the legal framework of the law, and when the question of legality and constitutional continuity becomes the paramount concern in the immediate aftermath of a revolution, the court becomes an important power broker, as one author called it. The court becomes the kingmaker, so to speak. A revolution generates its own legitimacy. That's the established legal position on revolution. I'll explain that later. A revolution generates its own legitimacy. And it is rather a political decision to conceptualize the revolution within a legal framework. The elites in Bangladesh made that political decision and thus began the legal takeover of the July Revolution. In one of the first moves, a new Attorney General was appointed on the 8th of August, apparently to foil an attempted judicial coup against the revolution. On the same day, under Article 106 of the Constitution, the President sought an advisory opinion of the Appellate Division regarding the formation of an interim government to fill the constitutional vacuum, given that the Prime Minister has resigned on the 5th of August and the President had dissolved the Parliament the day after. And this is how the Appellate Division responded, having heard the new Attorney General on the subject. I quote, বাংলাদেশ সুপ্রিম কোর্টের আপিল বিভাগ এই মতামত প্রদান করছে যে রাষ্ট্রের সাংবিধানিক শূন্যতা পূরণে জরুরি প্রয়োজনে মহামান্য রাষ্ট্রপতি রাষ্ট্রের নির্বাহী কার্য পরিচালনা নিমিত্তে অন্তর্বর্তীকালীন ব্যবস্থা হিসেবে প্রধান উপদেষ্টা এবং অন্যান্য উপদেষ্টা নিযুক্ত করতে পারবেন। মহামান্য রাষ্ট্রপতি উক্তরূপে নিযুক্ত প্রধান উপদেষ্টা এবং অন্যান্য উপদেষ্টাগণকে শপথ করাতে পারবেন। End of quote. The Appellate Division does not specifically mention this in their rather brief opinion, it's really brief opinion, but the subtext is, of course, the age-old doctrine of necessity. According to this doctrine, acts that are not permitted by the Constitution will still be constitutional if they were necessary and were done in good faith with the intention to prevent catastrophic consequences to the body politic and the social order, which may result, among other things, from a constitutional crisis. A few days later, a reputed lawyer of the Supreme Court, who later became a member of the Constitution Reform Commission, published a newspaper article spelling out Appellate Division's advisory opinion and explaining how the present government is both constitutional and legitimate. The author argues that the doctrine of necessity, although not written in the Constitution, is very much a well-established part of Bangladesh constitutional law and has been recognized by the Supreme Court on many occasions, the latest being in the judgments in the Third Amendment case in 2011 and the 16th Amendment case in 2017. The constitutionality of the government can be further defended, according to the author, on the ground that the unionist-led government took responsibility on the basis of the overwhelming demand of the people, to whom all powers of the Republic belong, according to Article 7 of the Constitution. More interestingly, the author then ventures into the question of legitimacy, and I quote them. The unionist-led government is legitimate because it has resulted from a revolution. A government formed through revolution acquires legitimacy as a result of struggle and sacrifice by and on behalf of the people in getting rid of old government. And then the author adds further, I quote, another way in which the legitimacy can be derived is the effective performance of the government, including ensuring orderly function of the society and the body politic. End of quote. Neither the author nor the Appellate Division specifically mentions the obvious, which clearly informs their arguments, and that is the theory of revolutionary legality propagated by Hans Kelsen some time back. In the rest of my talk, I will elaborate three strands of revolutionary legality as part of addressing a broader question, which is, what has the law got to do in a revolution? But before I do so, I need some water. I think no one else will speak for more than 1 hour today. The first strand, so the 3 strands of revolutionary legality that I'll be talking about, they are these. The first strand is a formalist revolutionary legality. The second one is purposive revolutionary legality. And the third one is instrumentalist revolutionary legality. And these through these 3 optics, we'll try to figure out to what extent law could have done better in dealing with the July Revolution or uprising, whatever you call it. And the other way around, to what extent what happened in Bangladesh in July and August could contribute to this kind of normative legal theory of revolutionary legality. Let's begin with the first, and that's Hans Kelsen. So the first one is formalist revolutionary legality. As part of this quest, as part of his quest, Hans Kelsen's quest for a pure theory of law, Kelsen proposed a doctrine of revolutionary legality that was ostensibly consistent with legality. And the background is, of course, the Bolshevik Revolution in Soviet Union and their approach to law. I'll talk about that finally, the third one, but that was the context. So rather than having this kind of instrumentalist position on law through revolution, what the Bolsheviks did, his argument was to have a consistent legal framework to explain revolutionary legality. And for positivist Kelsen, the crucial questions revolution posed for law and legal theory were: what effect, if any, does revolution have on the identity or the existence of a legal system? How does one know a legal system has come into being or has been destroyed? Or did a revolution instantiate a new legal system, and if not, under what conditions could it do so? Kelsen sought to provide jurists and scholars with a legal test that would answer these questions in his seminal work, The General Theory of Law and State, and of course, The Pure Theory of Law. And this is one of his most cited quotation. I don't know how many of you can actually read it from there. It doesn't appear fully, but let me read this out and follow me carefully, please. So he's saying, suppose that a group of individuals attempt to seize power by force in order to remove the legitimate government, legitimate not in moral sense, in legal sense, to remove the legitimate government in a hitherto monarchic state and to introduce a republic form of government. So if some people want to replace the authoritarian or monarchic system with a republic, that's what they have done. If they succeed in their action of removing the existing government, if they succeed, if the old order ceases and the new order begins to be efficacious because the individuals whose behavior the new order regulates actually behave, the people, by and large, in conformity with the new order, then this order is considered as a valid order. So it's mainly largely premised upon this idea of effectiveness, efficaciousness of the new regime. It is now according to this new order that the actual behavior of individuals is interpreted as legal or illegal. On the other hand, if the revolutionaries fail in their attempt to overthrow the government, if the order they have tried to abolish remains efficacious, then, on the other hand, their undertaking is interpreted not as illegal, a law-creating act, as the establishment of a constitution, but as an illegal act, as the crime of treason, and this according to the old monarchy constitution and its specific basic norm. As Professor Bhuya was telling in his introductory note, just imagine a situation on the 4th or 5th of August last year, and if nothing happened as a result of their sacrifice or anything, just think about the consequences to these youngsters, right? and the whole notion of legality. Many of those individuals would have been prosecuted for crimes against the state, the highest crime. So for Coulson, to a large extent, the creation of this new order and the legality, the legitimacy of this new order is largely hanging on this notion of effectiveness. And that is why military power becomes so important when it comes to major social changes, who has the control over the important apparatus of the state. It is important to note that Coulson regarded both the means through which the revolution occurs, whether violent or peaceful, and the objectives or aims of a revolution as irrelevant to determination of the revolutionary legality. What was needed, according to him, to determine the legality of a revolutionary order was a straightforward legal test where the revolution's success and efficacy meant the old rule norm was replaced by a new one. Now, of course, the scholarship has been polished since then, and there are far more nuanced understanding of what Coulson actually proposed. But this is largely the kind of classic take on the formalist strand of revolutionary legality. Coulson's focus on the efficacy or effectiveness in determining legality is not completely out of place. The requirement of a government as one of the 4 essential criteria of statehood as per the Montevideo Convention 1933 that all international law students know when they talk about the idea of state, it refers to an effective government irrespective of its democratic, monarchic, religious, or autocratic nature. And this is a well-established proposition in the positivist international law jurisprudence on statehood. There are a number of cases, including the Island of Palma case, 1928, Eastern Greenland case between Denmark and Norway, 1933, so on and so forth. In this sense, Coulson's test of revolutionary legality reinforces the notion of effective government before or after revolution as an already established requirement of statehood under positivist international law. The doctrine of revolutionary legality was applied in Pakistan. In 1958, as you know, in a very famous State versus Dosso case, and all constitutional law students have to study these cases. And through this theory, the Supreme Court of Pakistan rendered legitimacy to the first martial law proclamation in Pakistan. Since then, this doctrine of necessity became very popular in Bangladesh, in Fiji, in Lesotho, in Nigeria, in Zimbabwe, Uganda, and many more. It had a global appeal. Again, back in Pakistan, in Asma Jilani and government of Punjab case in 1972, the whole theory came under fierce attack that whether this kind of doctrine of legitimacy and revolutionary legality should or can legitimize this kind of military coup. So there was a backlash there. In Bangladesh, the Supreme Court rather happily applied this doctrine many times to justify various coups d'etat that happened in our political history, never really directly engaging with this kind of theories, but the idea was definitely embedded there. As you have already seen, the latest advisory opinion of the Supreme Court did the same without engaging with the doctrinal aspect. So Halima Khatun versus Bangladesh case, 1978, Haji Joinal Abidin versus the state, 1978, and then appeal in 1980. They all quite happily relied on this kind of phenomenon to justify military coup d'etat and saying that it has priority or precedence over the Constitution. However, in the Fifth Amendment case in 2005, for the first time, this idea of revolutionary legality and doctrine of necessity came under attack by Bangladesh Supreme Court, basically to nullify this idea of illegal usurpation of power and to maintain so-called constitutional supremacy as per our political structure and rule norm. However, if we look into the judgment closely, it was less a purposive revolutionary legality. I'm mindful of time, so I'm not going to actually read out everything, but for the second strand, the point to remember is a bunch of scholars attempted to kind of polish the classic formalist take on the doctrine of revolutionary legality. As I said, it largely depended on the efficaciousness or effectiveness of the government and the success of the revolution. They wanted to focus more on the very purpose of the Revolutionary Act. And the context is South Rhodesia, which we today know as present-day Zimbabwe. What happened there? In 1965, the white minority regime, they declared independence at a time when South Rhodesia was a self-governing British colony, and they were negotiating with the British colonial power regarding the independence and the decolonization process. Now, the British position was that decolonization will only happen if the regime in power, the white minority regime in power, they accept majority rule. Because the British position was, we are not going to endorse a white minority rule over a black majority. Kind of classic apartheid case. So frustrated with British position, the white minority government led by Smith, they unilaterally declared independence and called it a revolution. And it happened in 1965, in a year when the UN actually adopted the International Covenant on the elimination of all forms of racism or racial discrimination. So it was kind of a global scandal. And therefore, there was all sorts of condemnation from the UN, from African Union. At that time, it was known as Organization of African Unity, and so on and so forth. But the matter eventually ended up before the Rhodesian or Zimbabwean Supreme Court, based on 3 cases of arrest and detention. So whether there was a revolution and whether the new constitution or new legal framework should be the guiding stone for the actions of the government so far as the legality of the action is concerned. Initially, the court said there was no revolution because Britain still have certain control and the new government doesn't have absolute control. Therefore, on the ground of efficaciousness or effectiveness, they say there is no completed revolution. Therefore, the old regime prevails. Therefore, the new regime, new legal framework is not yet valid. Within 3 years' time, another case before the Supreme Court of Zimbabwe, and this time they said the revolution has been completed. Britain no longer has any specific control over Zimbabwean political aspects, and therefore we can declare the revolution has been completed, and therefore the new apartheid, like white supremacy-based legal framework is effective, and the new legal realm will decide the legality. Again, in this case, the court followed the classic formalist, positivist take on revolutionary legality. And that created a global outcry. How can you apply kind of theory, revolutionary legality theory, to justify an apartheid regime? And this is how a new version of revolutionary legality came into being, which came to be known as the purposive approach to revolutionary legality. And they talk about a principled position, that it is not only about effectiveness. Anyone can have effectiveness. Military regimes can have effectiveness. And in itself, that should not be the source of legitimacy. That's not what law is for. So their argument was, we have to look into the purpose, the objective. And they came up with a long list of potential objectives, such as moral principle, whether someone is benefiting from their own action, and so that's a long list. So this idea became popular because it doesn't look into the effectiveness per se, it looks into the very purpose of the Revolutionary Act. When it comes to the July Revolution, and if we see this through this purposive revolutionary legality framework as opposed to the formalist one, given the brutal political circumstances in which it happened, and the egalitarian future of social justice and inclusivity it promised, even if it's not materialized, it did have potential of passing the moral legitimacy test of revolutionary legality, as the scholars proposed. As I noted earlier, the decision of going to the court to seek legal backing for the post-revolutionary interim government was a political choice. Whether that was the right move or not is a different question. I'm not engaging with that. And also, it is of political nature. The point I'm trying to make here is this. In an ideal world, the Supreme Court, when it was approached by certain individuals based on that advisory opinion, the Supreme Court, in an ideal world, could have explicitly and proactively adopt the purposive approach, they adopted the formalist approach of need and necessity. They could have adopted the purposive approach to revolutionary legality. It could set the bare minimum of structural reform upon which the legality of the post-July regime would depend. Now, as I said, in an ideal world, the court in turn could offer a broad framework for building political consensus on important reforms and to some extent address the issues of the legal framework of the July Sanad or whatever you call it. But as we all know, the situation was of course far from ideal. We are talking about a judiciary which was very much part of the authoritarian state structure. The apex court at the time, already anxious about its own wrongdoings, could not be proactive on something it wished never happened. And in that case, the protagonists and the architects of judicializing the July Revolution are better placed to explain this missed opportunity of using the court, of advancing the core objectives of the July Revolution, since the decision was made to go to the court for the legal backing of the revolution. And finally, the instrumentalist revolutionary legality, again, as I said, it is one of the it predates the Kelsenian position on revolutionary legality. To put it very briefly, the idea was not, so the first two talked about the legality of the revolution itself and the role of law. The third one is rather interesting. It is more about to what extent revolution can use the law for advancing its revolutionary objectives. And I'm introducing this just to open up our thinking about the role of law in an act of revolution or large social movement, including mass uprising. Right? So it's not just that the act itself will depend on law for its own legitimacy. Another interesting way of thinking about revolutionary legality is to see and think and reflect to what extent revolution itself or uprising itself can use the law to achieve its legitimacy. Now, it is not my intention to assert which particular task the protagonists of the July Revolution should have assigned to the law in the immediate aftermath, because there are many options, and the choice was made in a political sense. Instead, what I'm highlighting is the multiplicity of the role of law in a revolution and demonstrated that the choice of legal engagement is a political one. It's not something given, it's not something fixed, and is influenced by vested interests of a plethora of power brokers against the backdrop of a series of external factors. And this leads us to certain issues of international law more specifically. Three specific areas of international law are of importance in influencing the nature, form, and substance of a revolution and its approach to the law: international law of state responsibility, international law of recognition, and the notion of democratic entitlement. So far as state responsibility of revolutionary governments under international law are concerned, two main questions are these. First, can international legal offenses or wrongdoings committed by revolutionaries be attributed to a new government or new state following a successful revolution? International lawyers have concluded that the answer to this question depends on the success of the revolution itself. So very much like the Kelsenian framework. With limited exceptions, states are generally not responsible for the acts of unsuccessful revolutionaries, but are responsible for the acts of successful ones. The second related question is whether there is legal continuity in terms of a shared international legal personality between the revolutionary actors and the new government or the state actor. And on this point, scholars generally agree that legal continuity exists, which results in holding revolutionary actors retrospectively responsible for these wrongful acts. The second one is more interesting, which is the idea of international law of recognition. As we know, The doctrine of declaratory theory means that recognition is not relevant directly to the creation of statehood. It's a colonial idea that unless you achieve certain level of civilization, you are not seen as a legitimate act. That colonial idea is gone. What we see today is rather a declaration of intention to work together as part of the recognition thing. There are exceptions, like the entities of Palestine. The statehood of Palestine is hanging on balance, but largely recognition doesn't have much value. When it comes to the recognition of government, it is even less important because various countries, including the UK, has this official position that UK does not recognize governments. They make phone calls to congratulate each other, but that is not an official policy. Again, exception the Taliban regime in Afghanistan, there was a question of recognizing the government per se. For a country like Bangladesh, and especially in devolution, it becomes quite murky because international law historically has a very ambiguous relationship with revolutionary entities. The classic international opposition was not to recognize any revolutionary government. So following the French Revolution, for example, European nations pursued a policy that denied recognition of revolutionary governments as they were not based on divine right of monarchs. And in the early 20th century, unsuccessful attempts were made through treaties and conventions to even outlaw revolutionary governments and impose a duty of non-recognition. So international law has always been resistant to this idea of any rupture or revolutionary change that creates turmoil for the entire global capitalist economic structure. We know many cases that we studied in our international law module on Soviet revolution, that how Western countries refused to work with the post-revolution regime in Russia or in China, but gradually based on practical needs, they came to work eventually based on the effectiveness criteria. And the final point is, of course, the democratic entitlement, which is not part of international law per se, but as you know, this theory was effectively applied even to invade many countries, like Libya. Before the NATO bombardment of Libya to remove the Gaddafi regime, the mainstream discourse in Western media was Gaddafi regime has lost its legitimacy. The idea emanating from Thomas Frank in 1992, after this Francis Fukuyama's moment of end of history to celebrate the liberal takeover of the world, was this, okay, sovereign states enjoy sovereign protection, but that protection should only come when the legitimacy is based on popular choice and support. Meaning, if the regime itself is not backed by its own people, meaning if you don't have democracy, then the regime itself should not enjoy the protection of international law. And that was one of the arguments, if not legal, but pseudo-legal or quasi-legal argument was floating around. It was very much in the air for a long time to implicate or effectively use regime change doctrine that was very popular in the 1920s and early 2000s. So again, coming here, democracy is very important for all sorts of good reasons. It is rather the lack of democracy which makes it obvious and necessary to go for this kind of uprising when people get really frustrated and angry. But what do we actually mean by democracy? Susan Mark, who visited IUB in 2018 from London School of Economics, in her famous writing, she talked about low-intensity democracy, meaning democracy which is reduced to electoral rituals alone rather than democratic culture and democratic institution. So a combination of international recognition of post-revolutionary government, international law of state responsibility, and this global norm of democratic entitlement, and seen with other local varieties of revolutionary legality, it becomes almost impossible for countries like Bangladesh to have that revolutionary rupture, because we are part of a larger picture, and it is a beautiful dream, but probably not a realistic one. So what happens as a result? And I'll be very quick. I know I'm beyond time. My apologies. So my final take is this. With reference, so we talked about uprising, we talked about revolution, but the July Revolution is not unique in the context of everything that I have discussed, the role of law in a revolution. As a matter of fact, in these highly integrated global economic and political structures, marked by neoliberalism and geopolitical complexities, a revolutionary rupture is almost impossible. in a country like Bangladesh, in the absence of a strong political will and popular consensus to go for major socio-political transformations and to endure, this is most important, to endure the pain such transformations bring forth in the short run, whether we had that political consensus for going through this pain. What we eventually ended up with instead is a passive revolution. What is it? With reference to the moment of resurgence leading to the unification of the state of Italy, Antonio Gramsci argues in his notes on Italian history that if new claimants, and this is very important, if new claimants to power lack the necessary social and military capacity to subjugate hitherto or existing dominant classes and establish complete hegemony over the new nation, if they lack that capacity, political and military, they prefer an alternative mode of operation. They take a toned-down approach in line with the available social and military strength, whatever you have, in which their demands for a new society are satisfied in small doses legally in a reformist manner, in such a way that it was possible to preserve the political and economic position of the old feudal classes. They themselves then emerge as the new bourgeoisie and embark upon a passive revolution by attempting a molecular transformation of the old dominant classes into partners in a new historical bloc, and only a partial appropriation of the popular masses in order first to create a state as the necessary precondition for the establishment of capitalism as the dominant mode of dominant mode of production. Now, of course, he was talking about at the state level following the resurgence in Italy. The July Revolution, and that's my final page, good news. The July Revolution of 2024 indeed resembles Gramscian passive revolution or Nishkriyo Biplov today. Various reform commissions have now submitted their reports. The National Consensus Commission is gradually making headways, and after some hard negotiations facilitated by the Consensus Commission, political parties have indeed agreed on some really important constitutional reform proposals, which is a brilliant news. Soon, a new democratically elected government will be in power. Last night we got not the date, which will be the job of the Election Commission, but we have some idea about when the election is going to happen. Democratically elected government will be in power, and the nation will return to some sort of normalcy after 1 year to give meaning to what we call a form of cyclicity. What is sadly missing in this process is a political reimagination, not just reform. And this reimagination is not the task of an elected interim government. This needed to come through a process of extensive dialogue amongst political parties, old and new, not imposed by the interim government. It should have been more proactive and internalized. But apparently the political parties, both old and new, unfortunately it seems, have less appetite for that process. Rather, we are left to count on the goodwill of our political parties to make incremental progressive moves. And it is ironic because trust is a rare commodity in Bangladeshi politics, I dare say. Thus, we collectively sow the seed of yet another passive revolution, probably not before long. And for a second, I do not really blame our political parties for not letting happen what could have potentially happened. The more pressing question is whether we, as a nation, were ready for enduring the pains and turmoil of revolutionary ruptures. Probably not. And no matter our perception about politicians, trust me, at the end of the day, no one knows the people better than the politician. In my lecture, I have also underscored how the international legal framework, with its neoliberal premise, does not leave room for any such revolutionary rupture in countries like Bangladesh. রক্তাক্ত জুলাইতে যা ঘটেছে সেটা হচ্ছে একটি গণ-অভ্যুত্থান, বিপ্লব না হয়ে ওঠার অসম্পূর্ণ গল্প। জুলাই হচ্ছে একটি নিষ্ক্রিয় বিপ্লবের উপাখ্যান, যা সম্ভবত আরও অনেক নিষ্ক্রিয় বিপ্লবের সূতিকাগার। আপনাদের সবাইকে ধন্যবাদ।
Thank you very much, sir, for this very descriptive, detailed, and informative session, or rather lecture, on the July Uprising. I believe after the conclusion of this lecture, you all did take some notes, and I don't see any notebooks. I don't see anyone with pens and paper taking any notes. It would have been helpful, definitely, for the courses that you are taking, and of course, some food for thoughts for all of you. Given the fact that this lecture was particularly based on the legal thoughts centering the uprising, maybe I would also ask you all to look into, as we saw it, the purpose, the consequences, the result of that movement, and whatever happened in the last 1 year plus 1 day, and what could have happened, definitely, that the legal sense, the legal lens, to be focused on those as well. With that, thank you very much, Professor Shahabuddin, for your keynote speech. Now I would like to call upon the guest of honor of today's... Okay, yes. If anyone has any questions, we are going to take 3 questions from the audience for Professor Shahabuddin. Thank you.
Okay.
Kindly.
ধন্যবাদ। আমি আমার ছাত্রছাত্রীদেরকে সচরাচর যে কথাটা বলি যে আইন বা নিজের কোনো ডক্টরিন বোঝার জন্য তার যে একটা ব্যাকড্রপ আছে, সোশিও ইকোনমিক অ্যান্ড পলিটিক্যাল ইকোনমিক ব্যাকগ্রাউন্ড, সেটা খুব গুরুত্বপূর্ণ। আমি শুনে খুব ভালো লাগে আপনি পাকিস্তান এবং শ্রীলঙ্কার কথা বলেছেন। এই দুটো কান্ট্রি তাদের পরিবর্তনের ঠিক পরপর যখন খুব একটা ভালো রেভলিউশনারি মনে ছিল, খুব বড় কোনো পরিবর্তনের কথা বলছিল, ঠিক তখনই তাদের দুটা কান্ট্রি IMF-এর বেল আউটের দরকার হলো। হ্যাঁ, IMF-এর বেল আউটের দরকার হলো, এবং যখন এই বেল আউটগুলো দরকার হয় তখনই কিন্তু আপনার যা করার ইচ্ছা, আপনার যে স্বপ্ন, বড় বড় পরিবর্তনগুলোর কথা বলেন, সেগুলো অনেকটাই হারিয়ে যায়। এই জন্যই আমি কথা যেটা বলছিলাম যে কখনই বিপ্লব বা যেভাবে রোমান্টিসাইজ করে না কেন, আমাদের যে রিয়ালিটি আছে সেটা ক্লাসিক রেভলিউশনের বাইরে কখনো যেতে পারে। এবং বাংলাদেশেও কিন্তু যে আন্তর্জাতিক স্বীকৃতি ওখানেই আসে, যখন আপনার একটা ইন্টিগ্রেটেড থাকেন, আপনাকে যদি বলে যে আপনি সব ট্রান্সফরমেশনে গেলে প্রো পিপল কাজের দিকে গেলে আপনার সেকশন আসতে পারে। সো আপনার ডক্টরিনাল নেসেসিটিটা তখন ওভাবে আপনাকে ব্যাখ্যা করতে হবে, হোয়াট ইজ নেসেসারি ফর দ্য স্টেট। আপনার যে একটা ইউনিকর্ন ভিশন অফ দ্য সোসাইটি আছে 50 years down the line, সেটা আপনি পার্সু করবেন উইথ অল ইউর গুড হার্ট and showing respect to the nearly 1,500 young people who sacrificed their lives so bravely. আর আপনি ইমিডিয়েট যে ক্রাইসিসটা আপনার হচ্ছে রেডিমেড গার্মেন্টস এক্সপোর্ট করার জন্য বা নানান জিনিসগুলো আছে, এটাই হচ্ছে ডিলেমা। এখন বাইরে থেকে আমরা নানানভাবে সমালোচনা করতে পারি, বাট দ্য পিপল হু অ্যাকচুয়ালি রান দ্য শো, উই হ্যাভ টু আন্ডারস্ট্যান্ড দেয়ার রিয়ালিটি অ্যাজ ওয়েল। সো লিগেল ডক্টরিনগুলোকে কনটেক্সটের বাইরে নিয়ে আমাদের আসলে খুব বেশি কিছু বোঝার এখানে নাই। এগুলো আমাদেরকে হেল্প করবে টু অ্যানালাইজ দ্য অ্যাকচুয়াল হ্যাপেনিং within the legal domain, but unless we take political economy seriously in our legal understanding, in our legal imagination, it is always going to be partial and incomplete. That would be my immediate response to your question.
Thank you, sir.
I think to some extent you have answered the question, because both you and me, we are very much product of the system. I had my undergrad and LLB degrees at the University of Dhaka. So it's possible, but I would definitely encourage whenever possible to incorporate more social legal, especially political economy. And it's not a problem in Bangladesh actually, even in the global north. I've been teaching in the UK for more than 10 years. We in the law schools, we do not take political economy seriously. Even in our human rights discourse, I teach human rights. That's part of my title. Unless you take political economy seriously, you don't understand the way human rights came into being as part of a larger liberal project of particular version of human rights, particular version of democracy, and particular version of capitalism. That's the complete package. And Fukuyama very kind of approvingly wrote about it. So yes, I fully agree with you, but I think there are far better and able individuals here in the audience who can reflect on this problem and this phenomenon in much deeper sense. I'll stop. At the end, I come from a different institution, so I'm no one to judge what is happening.
Thank you.
I think this is a very important point. So, a fair trial is there for a good reason. So, if we have the confidence in the process is very important, right? So, your first question is, I think, very important for the forward-looking aspect of the nation and how we move forward from here, rather than going for vengeance or anything like that. So, the important thing is to have faith from our side of view, from our side in the legal process. From their side, it is important to maintain the very high standard of adjudication and the associated criminal proceedings. Once we can get that right, then probably people will not have any perception that injustice has been done in the name of justice. So that might, to some extent, amend the kind of political device or whatever we have in the country. Can the judges be independent? I would say simply the judges should be independent. Whether it could be for them to decide. And not everyone has any legal obligation to become a judge, right? After your law degree, you can do many things. You can be an entrepreneur, you can do many things. But if you decide to be a judge, I think, or whatever position you could take, I think they should have respect for, not for anything else, but for the decision that they themselves make. If you cannot carry the weight of the position that you signed for, why do you go for that? So I think that's a conversation one should have with themselves, rather than people from outside like me and judge. I think that would be the very starting point.
Thank you, sir.
Questions and sir for your responses. With that, now we'd move on to the address by our guest of honor of today's event. That is Mr. Didare Hussain, who is the founding trustee and chairman of the IUB Board of Trustees for the year 2024-2025. I welcome him to come and give his address here.
Honorable Chairman of the UGC, Professor S.M. Faiz, distinguished speaker, keynote speaker of today, Professor Shahabuddin, our chair for this event, Vice Chancellor Tamim Muhammad. Assalamu alaikum and a very good day. I am daunted to speak here because I don't think I'm initiated enough to talk on this subject, particularly with legality and legal matters. One thing I'd like to emphasize that we have spent 1 year, we have come a long way, but as a nation, we are not very old. We are only 54 years old, that our courts speak in Bangla and administered in Bangla. So it would take time. We'll have many events like this, maybe in the future. If you go back to 71, it was because of, again, discrimination. And that discrimination continues because our system is as such. So this is something we should all ponder and think what we should do. Secondly, we talked about French Revolution. I would request you to read a book, La Miserable by Victor Hugo. That will give you a very good picture of what our distinguished professor was trying to tell you and how it fizzled out. Remember, 10 years after that French Revolution, Napoleon came out as the emperor. So that is again human history. And lastly, I used to talk about a very famous quote of President Abraham Lincoln. He said, before he became president, when he was campaigning, I believe, the house divided against itself cannot stand up. So these are the points I think we should think about, and I'll not extend it further. Thank you very much, all the participants, our scholars. I'm thankful to Professor Burhan and of course Hassanuzzaman for putting up the show, and also welcome other universities and deans who are present today. We much appreciate your presence, and again a heartfelt of thanks. Long live IUB and long live Bangladesh. Thank you.
Thank you very much, sir. Before we move on to the next speaker, I would like to presentate our chief guest, our guest of honor with a bouquet of flowers, and ask the volunteers to come and present it. Thank you. Thank you very much. Now I'd like to call upon our chief guest of today's event for our Professor S.M.A. Faiz, the chairman of the University Grants Commission, Bangladesh.
Bismillahirrahmanirrahim. Honorable Chair of the session, the Vice Chancellor, Independent University of Bangladesh, the Chairman of the Trustee Board, the distinguished guests, and the main person, the key person today, the speaker, Professor Shahabuddin of Birmingham University, the advisor, the School of Law of this university, the chair of the School of Law. Well, we have here the distinguished trustee board members, my very distinguished faculty members, and my dear students. Assalamu alaikum. আমি প্রথমে স্টুডেন্টদের পক্ষে বলবো, student of this great university, Independent University of Bangladesh, you have all the reasons to be proud of being students of this university. I, as the chairman of the University Grants Commission, I do certify that this is a university with clean image. Absolutely clean image. কিছুদিন আগে education advisor ছিলেন ওখানে. The Honorable Vice Chancellor was there. I was there with many other people. তো সেখানে কথা উঠছিল about the private universities of this country. Someone mentioned about independent university and said, this is in one university, যেখানে trustee board member are sitting allowance দেন না. Then someone looked at me. I said, yes, এটা যে আমি শুধু ইউনিভার্সিটি গ্রান্টস কমিশনের চেয়ারম্যান হওয়ার পরে জানতে পারলাম, তা না. I came to know about this many years ago. যখন Mr. Rashid Chaudhary was the chairman of the trustee board. তা ওনার বাসায় আমেরিকায় একটা ফ্যামিলি গ্যাদারিংয়ে সে খুব এমফ্যাটিক্যালি বলছিলেন এবং I had all the reasons to believe him. তা এটা সত্যিই তাই. আরেকটা কারণ যে আমি সবাইকে আন্তরিক অভিনন্দন জানাবো এখানে ছাত্রছাত্রীদেরকে, যে প্রাইভেট ইউনিভার্সিটি কি ভূমিকা পালন করলো জুলাইয়ে Auguste. My goodness, this we have never seen. Private university. ভাবছিলাম যে এরা কারা, এরা তো ওই বিসিএস পরীক্ষা দিবে না. আমি তো PSC chairman ছিলাম 93 থেকে 98. 93 to 98 I was the youngest chairman of the Public Service Commission, and today youngest ever chairman, and today I am the oldest ever chairman of the University Grants Commission. তো ওইখানে দেখতাম যে প্রাইভেট ইউনিভার্সিটির ছেলে মেয়েদের দেখেছি বলে মনে হয় না তারা বিসিএস পরীক্ষা দিচ্ছে. তারপরে এরা এগিয়ে আসলো কেন? তারপরে ভাবলাম এটা কি ওই সন্তান যারা নিরাপদ সড়ক আন্দোলনে পার্টিসিপেট করেছিল, উই ওয়ান জাস্টিস, হোয়াট এ পুইসেন্ট কল দ্যাট ওক আপ অল। এটা ভাবছিলাম, তবে রেফারির দায়বদ্ধতার জায়গায় এটাই সৃষ্টি হয়েছিল যে আমার ভাইদেরকে এভাবে হত্যা করছে, আমি বসে থাকবো। যেভাবে এগিয়ে আসলো সবকটা প্রাইভেট ইউনিভার্সিটি, ইনক্লুডিং দিস ভেরি ইউনিভার্সিটি, তো সত্যি গর্ব করার মতো। আমরা অনেক আশা পেয়েছি এখানে যে ইয়েস, দিস আর দি স্টুডেন্টস হু আর রিয়েলি দ্য ফিউচার অফ দিস নেশন। তা আমি এই যে আরেকটা স্লোগান যেটা কোটা না মেধা, তা এখানে এইটা, আচ্ছা বিফোর দ্যাট আমাকে যখন প্রফেসর বোরহান, আমার পুরনো কলিগ, টেলিফোন করে বলল যে আই হ্যাভ টু কাম, তা আমি কিন্তু ইন মাই কেরিয়ার অ্যাজ দ্য চেয়ারম্যান অফ দ্য ইউনিভার্সিটি গার্লস কমিশন, অ্যাজ চেয়ারম্যান অফ দ্য পাবলিক সার্ভিস কমিশন, অ্যাজ দ্য ভাইস চ্যান্সেলর অফ দ্য ইউনিভার্সিটি, অনেক অকেশনে আমাকে না বলতে হয়। সো আই নো বিউটিফুল ওয়েজ অফ সেইং নো। দেয়ার আর সো মেনি বিউটিফুল ওয়েজ অফ সেইং নো। কিন্তু ইয়েস বলার একমাত্র ভালো উপায় হচ্ছে not to delay but say yes the moment you were requested. The Professor Burhan যখন আমাকে রিকোয়েস্ট করে, there is no way that I can say no, so I had to say yes. তারপরে যখন এইটা কিসের উপরে আলোচনা বললেন, the July Uprising in Legal Thoughts, তা এটা একটু ভাবলাম যে এটা তো ডেফিনেটলি একটা ইন্টারেস্টিং বিষয়, আমিও শিখবো। আমি একটা লাইফ লং লার্নিং প্রসেসে এখনও তাই। এবং আমি শিওর ছিলাম যে প্রফেসর বোরহান নিশ্চয়ই আশা করবে না যে আই টক অন লিগাল অ্যাসপেক্টস, and I was sure about it. However, as I was listening to the speaker, it was not late before I started learning some wonderful points about the legal aspects. Yes, doctrine of necessity, but to me it was impending necessity. It was impending necessity to remove one illegal government. And it was impending necessity that there is an interim government to run the show. তা আমি যেটা যে লিগাল অ্যাসপেক্টে যদি মানে অ্যাটলিস্ট মেধা না কোটা, এই বিষয়টা আমাকে কিন্তু বহুদিন থেকে স্পর্শ করেছে, সিন্স আই ওয়াজ দ্য চেয়ারম্যান অফ দ্য পাবলিক সার্ভিস কমিশন। ওখানে দেখতাম যে মুক্তিযোদ্ধাদের একটা কোটা, অথচ আবার দেখছি there are many freedom fighters who are not genuine freedom fighters. Fake certificate, political ওয়েতে প্রসেসের মধ্যে the certificate এসছে। But there were some very genuine freedom fighters, তারা কিন্তু কোনো সার্টিফিকেট নেননি। তো এখন ফেক ফ্রিডম ফাইটাররা বেনিফিটেড হবে জাস্ট বিকজ অফ বিং সো কল্ড ফ্রিডম ফাইটার্স, আর জেনুইন ফ্রিডম ফাইটাররা তারা ডিপ্রাইভড হবে। এই জিনিসগুলো আমরা বলতাম, আমাদের অ্যানুয়াল রিপোর্টে বলতাম, প্রত্যেক অ্যানুয়াল রিপোর্টে বলতাম যে আমাদের তো তারা জেনুইন ফ্রিডম ফাইটার তালিকায় ঠিক করতে পারলাম না, এটা তালিকাটা ঠিক করাটা বেশি প্রয়োজন হয়ে গেছে। তার আগে যে কোটাটা দিচ্ছি আমরা, দিস ইজ সামথিং এলস, দেন কেম দ্য চিলড্রেন অফ ফ্রিডম ফাইটার্স। তখন আমাদের অ্যানুয়াল রিপোর্টে বলতাম যে মাই ফাদার ওয়াজ নট এ ফ্রিডম ফাইটার, ইজ দ্যাট মাই ফল্ট? Or my father was a fake freedom fighter. He took the advantage of being a fake freedom fighter. Now I shall also get that benefit. But my father was a freedom fighter. But he didn't take a certificate. He deprived himself. Now I will be deprived with myself. এটা তখনও কিন্তু আমরা নিতে পারছিলাম না। তারপরে যখন নাতিদের বিষয়টা আসলো এবং আরও অনেক কিছু সাথে জড়িত হয়ে গেল যেগুলো মানুষ নিতে পারছিল না, ছাত্রছাত্রীরা শুধু না, অভিভাবকরা নিতে পারছিল না, তখন তারা এখানে এগিয়ে আসলো, এত জীবন দিল, এত মানুষ জীবন দিল, কি সাহসিকতার সাথে তারা দাঁড়ালো বুলেটের সামনে। দিস উই হ্যাভ নেভার সিন ইন আওয়ার লাইফ, যে এইভাবে করে বুলেটের সামনে। যে আমি স্বাধীনতার পরের কথা বলছি, মহান স্বাধীনতা আন্দোলনের পরের কথা, এটা কিন্তু আমরা দেখিনি। এবং একটা আচ্ছা, আমি তার আগে একটু বলি যে পরিবর্তনটা তারা আনলো, এই পরিবর্তনটাকে আমি কীভাবে দেখব। আমার কাছে মনে হয়েছে যে in nature the most beautiful example of change is how caterpillar যেখানে ক্লিপ করে, that caterpillar is learning to fly, becoming butterflies. কি সুন্দর একটা এক্সাম্পলের নেচারে ক্যাটারপিলার বাটারফ্লাই হয়ে যাচ্ছে। On 5th of August we felt like we all were butterflies. এত ভালো লেগেছিল তখন আমাদের। তাইতে করতে গিয়ে কত জীবন দিল, কত আমাদের সন্তানরা পঙ্গু হলো, এবং কত যোদ্ধা কি সাহসিকতার পরিচয় দিল। আমরা তাদের প্রতি গভীর শ্রদ্ধা নিবেদন করছি। আমাদের পরিবর্তনের উপরে একটা, যে নিজেকে আগে পরিবর্তন করো, তো সেটা মাইকেল জ্যাকসনের দ্য ম্যান ইন দ্য মিরর মনে আছে নিশ্চয়ই অনেকের, যে আয়নার সামনে দাঁড়িয়ে আয়নাতে যাকে দেখতে পাচ্ছে, দ্য ম্যান ইন দ্য মিরর, দ্যাট মিনস হি হিমসেলফ ওয়াজ ইন দ্য মিরর। And then Michael Jackson's গানটা বলছে, I want to start with the man in the mirror and I want to change. So I want to change starting from me. আমার নিজেকে দিয়ে আমি পরিবর্তন করতে চাই। এইভাবেই কিন্তু সবাই এগিয়ে এসেছিল, নিজেকে দিয়ে পরিবর্তন করা, কেউ কাউকে বলতে হয়নি। দ্যাট ওয়াজ দ্য চেঞ্জ। আমাদের আরেকটা গানের কথা বলি, সেটা হচ্ছে মানি ট্রি। এটা ল্যামার, আমেরিকান সিঙ্গার। তো সে বলছে যে বন্দুকের নলার সামনে যে দাঁড়িয়ে মৃত্যুবরণ করছে, সে কিন্তু সারা জীবন জীবিত আছে মানুষের মনে। আর যে লোকটা ট্রিগার টেনে ধরছে, তাকে মারছে, সে ঘৃণিত একজন ব্যক্তি হিসাবে টিকে থাকবে। অর্থাৎ তাকে লোভ লালসার দ্বারা সে আকৃষ্ট হয়েছে। এই জন্য হচ্ছে মানি ট্রি হচ্ছে লোভ লালসার প্রতীক। লোভ লালসা হচ্ছে কি এখানে, যে আমি যদি আমার প্রাইম মিনিস্টারকে বলতে পারি আমি একজন মানুষকে হত্যা করেছি, আমি পুরস্কৃত হব। দ্যাট ওয়াজ দ্য সিনারিও। মানুষকে বাঁচাবার জন্য পুরস্কৃত হব না, মানুষকে মারার জন্য পুরস্কৃত হব। লুক এট দিস। এবং একটা ছবির কথা বোধহয় মনে আছে সবার, মিস্টার ইন্ডিয়া was a real hero, but there was a real, genuine villain. ভিলেনটার কি ছিল? মানুষকে ফুটন্ত পানিতে ছেড়ে দিচ্ছে, সে মারা যাচ্ছে, এই ভিলেনটা বলছে আমি খুশি হয়েছি। সুতরাং এটা ছিল সিনেমার, কিন্তু আমাদের রিয়েল লাইফে we have seen that. মানুষকে হত্যা করতে বলা হচ্ছে। We have heard about this. তো এটা থেকে আমরা মুক্তি পেয়েছি। We are grateful to these young boys and girls. যেদিনকে রোকে হলের মেয়েরা বেরিয়ে আসলো, that also we were surprised. এই মেয়েরা যে এই ভূমিকা রাখছে, my goodness, we never seen that. আর একটা জিনিস আমি বলি, যে আমরা তো প্রায় বলি, চীনের একটা এক্সাম্পল দিয়ে বলি আমরা, চীনে গণতন্ত্র নাই, মানুষের কথা বলার অধিকার নাই, there is no democracy at all. সেখানেও কিন্তু 1998 সালের কথা মনে করে দেখেন। 98 সালের যে একটা, ওটাকে বলা হয় যে টিয়ানানমেন স্কোয়ার, ওখানে ওই 6 সপ্তাহ কিন্তু ছাত্রছাত্রীরা ওটা দখল করে রেখেছিল, ওরা অবরুদ্ধ করে রেখেছিল, এবং মিলিটারি জান্তা তাদের সাথে নেগোশিয়েট করেছে। 6 সপ্তাহ নেগোশিয়েট করেছে। 6 সপ্তাহ নেগোশিয়েট করার পরে যখন দেখতে পাচ্ছে যে না, সম্ভব হচ্ছে না, তারা যাচ্ছে না কোনোভাবে, টেকিং 6 উইকস, চিন্তা করে রাখেন। তারপরে তারা মিলিটারি ডিপ্লয় করলো। সেই সময় একটা ছবি, 4টে ট্যাঙ্কের একটা বহর রাস্তা দিয়ে আসছে, একটা তরুণ সামনে গিয়ে দাঁড়াচ্ছে। অনেকের বোধহয় মনে আছে সেই ছবিটা। সে তরুণটা সামনে গিয়ে দাঁড়াচ্ছে, ট্যাঙ্ক কিন্তু ঘুরে যাচ্ছে, ট্যাঙ্ক সরে যাচ্ছে, আবার তরুণটা সেই ট্যাঙ্কের সামনে দাঁড়াচ্ছে, আবার ট্যাঙ্ক সরে যাচ্ছে। থার্ড টাইমের পরে ট্যাঙ্ক থামিয়ে গেল। এই তরুণটা উপরে উঠলো, উঠে সোলজারদের সাথে কথা বলল, তার গ্রিভেন্সে জানাতে পেরেছিল। অনেকেই বলে যে তার নাম ছিল মিস্টার ওয়াং। হয় এর চেয়ে বেশি জানি না, তারপরেও দেখেন সেখানে সেটা হয়েছিল। আর এখানে কীভাবে করে ওই যে সিনারি একটা দেখতে পারলাম আমরা। এটা তারপরে বলা হয়েছিল, বেশ কিছু মিডিয়াতে এসেছিল 100 ছবির কথা, 100 পিকচার্স। দিস ওয়াজ ওয়ান দ্যাট চেঞ্জ দ্য ওয়ার্ল্ড, 100 ছবির মধ্যে একটা ছবি এটা। আর আমাদের যাদেরকে মারা হলো, মাই গুডনেস, পুরো পৃথিবীকে আলোড়ন ধরিয়ে দিয়েছে। দ্য হোল ওয়ার্ল্ড লুকড অ্যাট দেম উইথ ওয়ান্ডার অ্যান্ড অ। এই জিনিস তো আমি তো বলবো যে আমাদের বিষয়ে, আমাদের সম্পর্কে পুরো পৃথিবী অবাক হইতে গেছে যে ওদের বাচ্চা ছেলে মেয়েগুলো কী করতে পারে। তা এখন মাই ডিয়ার স্টুডেন্টস, তোমাদের কন্ট্রিবিউশনের জন্য আমাদের এক্সপেকটেশন অনেক বেড়ে গেছে। তোমাদের দিকে তাকিয়ে আছে দেশ, জাতি, তোমাদের দিকে তাকিয়ে আছে জন্মভূমি। তোমরা আমাদের ভবিষ্যৎ। ভালো থাকো, সুন্দর থাকো। আমার তো লিগ্যাল অ্যাসপেক্টে বলার কোনোভাবে উপায় নেই, বাট ডেফিনেটলি আই হ্যাভ লার্ন এ লট। তো সেগুলো রিপিট করতে গেলে ইট উইল মেক অ্যান ইনসিপিড স্প্রেড অনলি। সো থ্যাংক ইউ ভেরি মাচ, থ্যাংক ইউ অল, আল্লাহ হাফিজ।
Thank you, sir, for your wise words. Although it wasn't legal, it was definitely insightful for the students, I'd say. Finally, I would like to call upon the chair of today's event, the Vice Chancellor of Independent University Bangladesh, Professor M. Tamim, to kindly give his address for this event.
Honorable Chief Guest, Chairman EGC, Chair Board of Trustees, Advisor to Law Department, Dean of Law, and our honorable guest, Professor Shahabuddin from Birmingham University, my dear colleagues, and dear students, good afternoon. It was a very interesting talk. I was following, and as our Chairman sir was saying, I was trying to learn. How can you legalize a revolution? Before that, we have to find out what is the legal way of reflecting people's mind, and how is the legal way of changing a government. So it all started from there. All the previous turmoils, all the previous movements, everything happened because you block the legal way of changing government. So what do? নিয়মতান্ত্রিকভাবে যখন সরকার পরিবর্তন করা যায় না, তখন মানুষের আশা আকাঙ্ক্ষার প্রতিফলন ঘটাতে অনিয়মতান্ত্রিক পন্থা গ্রহণ করতে হয়। সেটা নানাভাবে নানা রূপে আসে এবং তাকে লিগ্যাল ফ্রেমওয়ার্কের মধ্যে আনতেই হবে। সেটাকে তখন কি লিগ্যাল বলা যাবে, ইললিগ্যাল বলা যাবে? I don't think so. So সভ্য ডেমোক্রেটিক নেশন হিসাবে আমরা যেই প্রসেসগুলো রেখেছি, if we block those processes, there is going to be a pent-up tension and pressure that will build up over years, and that is exactly what happened. For 15 years, people didn't have any way of, so revolution need to be looked into from that perspective. From our speaker's presentation, I have a feeling that old revolution that we heard, the Bolshevik Revolution, the French Revolution,
That kind of revolution is, I don't think, ever going to happen. Because the world order, the economic situation, the globalization, everything has created a world in such a way that rapture that he was talking about, I think it is just absurd. It will never happen, that rapture, the discontinuation, the complete new start. It's very difficult under the current world order. It is changing, but I don't know how far it will change or whether it will really dislodge the current situation. It was very interesting to hear the questions from the students. I would love to have more discussion from the students. And I would also love to have our students to challenge the speakers. Hopefully in future, I thank the Law Department for this public lecture. And if the content of the talk is given to the students prior to the lecture, at least a summary, that will be good, because then students can prepare. They can come, and university is the place where you exchange ideas. When you differ, you have different views, and that views need to be heard, to be argued on, and improve our learning. So university is a place where there should not be any bar in terms of expressing your opinion. We were stopped expressing our opinion. University is the place where we do all this academic analysis. Today's presentation was an academic analysis of the revolution. Nishkriyo Biplab, no? Achha. That was an interesting word, Nishkriyo Biplab. So, Shokriyo Biplab ado hobe kina ami jani na. But ei dhoroner alochona gulo ashole we need to talk, we need to discuss, and you need to think. We heard the July Declaration yesterday. We are hopeful that the fundamental aspect of that declaration is the fulfillment of the aspiration of the people, what we are aspiring. Hopefully, the new government and the new generation who has gone through this revolution, who has brought this revolution, will bring meaningful changes to this country so that we can raise our head with full freedom and dignity. Thank you.
Thank you very much, respected VC, Vice Chancellor, for your speech. Before we move on to the concluding session, or rather the concluding remarks of today's event, I would like to request our respected Vice Chancellor to kindly felicitate our Chairman of the University Grants Commission with a token of appreciation. Thank you. Next, I'd like to request our guest of honor, the Chairman of the Board of Trustees, Mr. Didar Hussain, to kindly felicitate the keynote speaker of today's event, Mohammad Shahabuddin sir, with a token of appreciation. Thank you. Thank you very much. Now I'd like to call upon the advisor and the adjunct professor of School of Law of Independent University Bangladesh, Professor Dr. Burhanuddin Ahmed, to kindly give his concluding remarks. And my apologies, Burhanuddin Khan, for his concluding remarks and vote of thanks.
it is actually very difficult to be the last speaker, especially when you have the Vice Chancellor, Speaker, the Chairman, University Grants Commission, the Dean School of Law, but nevertheless, as a ritual, someone has to be the last. So it has been for me today. Today's chair of this public lecture, our Vice Chancellor M. Tamim, Chief Guest Professor S.M. Faiz, former Vice Chancellor of Dhaka University, former Chairman Public Service Commission, and a very special professor to me. Professor Faiz was Vice Chancellor when most of you were not born or very young. He was Vice Chancellor of Dhaka University from 2002 to 2009. And I became very nostalgic sharing this audience before the students today after 16 years. The last time was 2009 when he left as Vice Chancellor, when I left as the Dean. So under his supervision, I was Provost, I was Dean. So we have a huge amount of experience working with the students. So I'm so glad that Sir agreed to come today. Present here is also Chairman Board of Trustees, Mr. Didar. The speaker, my former student, I take so much pride in my former student, Professor Shahab, and also the Dean School of Law, my former student, also the head of the department of IUB Law Department, my former student. And I can see some of my former students who are faculties in different universities who are present here, and students from this very day. Either you all have been in the street or relaxing or resting after a month-long exhaustion. And today, you are all here to listen to what you had or the implications of what you had done year before. The private university students here. Last year, 17 জুলাই যখন ঢাকা বিশ্ববিদ্যালয় থেকে আইন প্রয়োগকারী সংস্থারা ছাত্রদেরকে বের করে দিল, তখন আমরা অনেকে ভেবেছিলাম বোধহয় আর কিছু হবে না। The students of private university came as angels, along with all others. I believe they all knew the risk of such efforts, such activities. The regime which failed and fled actually anticipated such an event 16 years back. No, 14 years back. It seems to me. Because in 2011, February, they amended the Constitution and provided a provision by which overthrowing a government, the very act of overthrowing a government, was made punishable with death penalty. A very unprecedented provision in the Constitution. No other constitution in the world has such kind of provision. সুতরাং বিগত সরকার বুঝতে পেরেছিল যে একটা কিছু এরকম কোনো না কোনো দিন হবে, এবং সেটা ঠেকানোর জন্যই কিন্তু তারা আইনের মধ্যে এটা রেখেছিল। But then it looks like that you all have violated that provision of the law. But the law that you have violated, the same law, the same constitution tells or guarantees your right to life, your right to liberty. The government in power did not ensure that. Rather, they're taking up your lives. In such a situation, you all came up. But how do you justify that what you did is right? In order to justify, the first tool I would give you is the American Declaration of Independence, 1776. 1776 সালে যে আমেরিকার যে ইউনিল্যাটারাল ডিক্লারেশন অফ ইন্ডিপেন্ডেন্স, সেখানে তারা কি বলছে? সেখানে বলছে যে রাষ্ট্রের দায়িত্ব হচ্ছে আমরা যে সমস্ত কতগুলো অধিকার, সাচ অ্যাজ লাইফ, লিবার্টি, পারসুইট অফ হ্যাপিনেস, এগুলা নিশ্চিত করা। If the government fails in doing that, what do you do? Let me read it. It says, whenever government becomes destructive, it is the right of the people to alter or abolish it and to institute new government. It further says, it is their right, it is their duty to throw such government and have a new government. So you all are actually supported by the American Declaration of Independence. The next argument you can put through is the principle of effective control, which Professor Shahab said, referring to Professor Kelson's theory. Apart from Kelson's theory, the effective control means the regime failed and fled, and because of tomader andoloner jonno. But then you had the effective control of the country. You had the control, and you installed a government. So the effective control the principle ta International Court of Justice je advisory opinion e bola ache different context e, but ওই context e kintu amra abar amader context e, since we had the effective control, since the former prime minister fled, there's a legal vacuum. So keep aside the constitution, let's talk about necessity, let's think of what we need to do, and we did that. So what we did is, in the eye of law, legitimate. This is the kind of argument we all need to put forward. আমরা আজকের এই দিনে গত বছর যারা জীবন দিয়েছেন, যারা পঙ্গুত্ব বরণ করেছেন, যারা দৃষ্টিশক্তি হারিয়েছেন, আমরা তাদেরকে স্মরণ করি এবং আমরা যেন সবসময় তাদেরকে স্মরণ করে রাখি এবং ভবিষ্যতের দিকে যেন আমরা খেয়াল রাখি আগামীর কোনো সরকার, আগামীর কোনো রেজিম যদি এভাবেই আচরণ করে, ইতিহাস থেকে যদি শিক্ষা না নেয়, আমরা যেন আবার ঘুরে দাঁড়াই, আবার যেন দেশটাকে ঠিক করার চেষ্টা করি। আপনাদের সকলকে ধন্যবাদ। থ্যাংক ইউ।
Thank you very much, Professor, for your concluding remarks and vote of thanks. With this, the official part of today's public lecture ends here itself. I have been requested by the photographer for the guests to kindly sit for a while. They are going to take a group photo. Thank you.